Friends, welcome to today's discussion. The subject is the role of the subordinate judiciary in the matters of protection of human rights. To start with, in every state of India, there is a system of subordinate courts below the respective high courts. The Constitution of India makes a few provisions in Articles 233 to 237 to regulate the organizations of these courts and to ensure independence of judges. There are district judges, the civil judges of senior division and civil judges of junior divisions on the civil side. On the criminal side, there are session judges and the magistrates. Every state in India organizes the powers and procedures of the courts. For example, for the state of Manipur, the Manipur Courts Act 1955 provides the powers, structures and functionings of these civil courts within the states. The court of the district judge is the principal civil court of original jurisdiction, and below this court there exists the court of civil judge senior division and civil judge junior divisions. As far as their jurisdiction, they function within the prescribed territorial limits with pecuniary jurisdiction of entertaining the suits up to the value of rupees 20,000 by the civil judge junior division, and beyond that the value up to any limit can be entertained by the civil judge senior division. As far as civil appeals, an appeal up to the value of rupees 50,000 shall lie to the district judge, and beyond that value an appeal shall go to the high court. In criminal matters, there exists the court of sessions, the judicial magistrates and the executive magistrate that are function under the Code of Criminal Procedure 1973. In the study of the role of the subordinate courts in the matters of protection of human rights, it requires a classification in two heads: the role of the civil courts and the role of the criminal courts. The role of the civil courts as regards the regulation of the procedure of the courts of civil jurisdiction. The role of the civil courts as regards the regulation of the procedure of the courts of civil judicature. The Code of Civil Procedure 1908 is the law to consolidate and amend the laws relating to civil procedures. In India, Section 9 of the Code lays down that the court to try all civil suits unless barred. The courts shall have jurisdiction to try all suits of civil nature, excepting suits of which their cognizance is either expressly or impliedly barred. The explanation to the section clarifies that a suit in which the right to property or to an office is contested is a suit of civil nature, notwithstanding that such right may depend entirely on the decision of the questions as to the religious rites or ceremonies. Every suit shall be instituted by the presentation of a plaint or in such manner as may be prescribed. In every plaint, facts shall be proved by affidavits. Every suit shall be instituted in the court of the lowest grade competent to try it. It is relevant to refer to the Specific Relief Act 1963, which is in force in India since the 1st of March 1964. A mature legal system endeavors to provide not merely a remedy for every right infringed, but also an adequate remedy. It was in this process of a search for effective remedial action that specific relief emanated from the equity courts in England. The principles built by successive chancellors of England in this branch of the law have been borrowed by Indian courts and have served to enrich Indian law. The Specific Relief Act 1963 came into being as an Indian law thereafter. The Act declares in section 4 that specific relief can be granted only for the purpose of enforcing individual civil rights and not for the purpose of enforcing a penal law. The provisions of specific relief under the Act envisage, firstly, suits for recovery of specific movable or immovable property which may be recovered in the manner provided by the Code of Civil Procedure 1908. Secondly, suits for specific performance of contract may be granted by the court when there exists a standard for ascertaining actual damage caused by the non-performance of the act agreed to be done, or when the act agreed to be done is such that compensation in money for the non-performance would not afford adequate relief. Thirdly, power to award compensation in certain cases. Fourthly, power to grant relief for possession, partition, refund of earnest money, etc. So, let us discuss the role of the civil courts in granting injunctions. The Specific Relief Act 1963 provides that the courts can grant preventive relief at the discretion in the nature of temporary or perpetual injunction. Temporary injunctions are such as to continue until a specified time or until further orders of the court, and they may be granted at any stage of the suit and are regulated by the Code of Civil Procedure 1908. A perpetual injunction can only be granted by the decree made at the hearing and upon the merits of the suit. The defendant is thereby perpetually enjoined from assertion of a right or from commission of an act which would be contrary to the rights of the plaintiff. The Code of Civil Procedure 1908 provides under Order 39 a provision for enabling the courts to grant temporary injunction. The court may order or grant temporary injunctions to restrain such act or make such order for the purpose of staying and preventing the wasting, damaging, alienation, sale, removal or dispossession of the property of dispossession of the plaintiff or otherwise causing injury to the plaintiff in relation to any property in dispute in the suit as the court thinks fit until the disposal of the suit or until further orders. perpetual injunction may be granted to the plaintiff to prevent the breach of an obligation existing in his favor, whether expressly or by implication. When a defendant invades or threatens to invade the plaintiff's right to or enjoyment of property, the court may grant a perpetual injunction. The term injunction is ordinarily understood to grant of preventive relief only, but the courts can also grant mandatory injunction when to prevent or breach of obligation it is necessary to compel the performance of certain acts. When the court is capable of enforcing, the court may in its discretion grant an injunction to prevent the breach complained of and also the performance of the requisite acts. The role of the courts is significant in the areas of granting declaratory decrees also, where in any suit it is shown that any person is entitled to any legal character or to any right as to any property against any person denying or interested to deny his title to such character or right, the court may in its discretion make a declaration that he is so entitled. A declaration made under the Specific Relief Act 1963 is binding only on the parties to the suit or persons claiming through them respectively. So now let us discuss the role of the civil courts in suits of public nature, also known as relator actions. Section 91 of the Code of Civil Procedure 1908 lays down the role of the courts in public nuisances and other wrongful acts affecting the public. In most of the suits, the claims made are to vindicate a private right and to obtain a decree which is binding between the parties or their representatives in interest, and to no others. But Section 91 is a suit of public nature and popularly understood as the relator actions. The provision goes, in the case of a public nuisance or other wrongful act affecting or likely to affect the public, a suit for declaration and injunction or for such other relief as may be appropriate in the circumstances of the case may be instituted first by the Advocate General or with the leave of the court by the two or more persons, even though no special damage has been caused to such persons by reason of such public nuisance or other wrongful act. This is a suit to vindicate public right by filing suit and may also be termed as public interest suit of an extensive remedial nature of protection of public right in the way of civil suit. The ADR under the Code of Civil Procedure, as we know, litigation is cumbersome and time-consuming job, and there must be an end to litigation. A civil suit pulls on endlessly and will continue in appeals before the district judge and the high courts and takes years and even decades to settle a matter. not only money and time taxing, there is the dimension of mental agony. In order to remedy this malady, the provision of settlement of disputes outside the court, popularly known as alternative dispute redressal, in short ADR, has been introduced in the Code of Civil Procedure 1908 by incorporating the provision, and it became a legal provision since the 1st July 2002. The provision goes like this, where it appears to the court that there exist elements of a settlement which may be acceptable to the parties. The court shall formulate the terms of the settlement and give them to parties for their observations. And after receiving the observations of the parties, the court may formulate the terms of a possible settlement and refer the same for arbitration, conciliation, judicial settlement, including settlement through lok adalats or mediation. The role of the subordinate criminal courts. Let us discuss in this regard also. The criminal courts in India function under the provisions of Code of Criminal Procedure 1973 as far as the role of the criminal courts in protecting human rights is concerned. One will certainly feel the provisions of issuing search warrants under the court, where the criminal courts are empowered to issue orders akin to a writ of habeas corpus. The right to life and personal liberty is most precious right, as human liberty is birthright, apart from a guarantee of the right under Article 21 of the Constitution of India. Section 97 of the Code of Criminal Procedure made provisions for search of persons wrongfully confined, and Section 98 is the power of the court to compel restoration of the abducted females. When any person is detained unlawfully, a writ of habeas corpus that can be issued by the High Court can direct any detaining authority or person to bring the detainee before the court to examine the legality of such detention, and if found to be illegal, an order is issued for setting the detainee free. But a habeas corpus writ cannot be used to make search of a person detained and wrongfully confined and hunt out a detainee. A search warrant can hunt out a detainee and set him free. The powers are given to a district magistrate, a subdivisional magistrate, or a magistrate of first class who can exercise this power. Under Section 97, if the class of the magistrates, as mentioned above, has reason to believe that a person is confined under such circumstances that confinement amounts to an offence, he may issue a search warrant, and the person to whom the warrant is directed may search for the person so confined, and such search shall be made in accordance therewith, and the person, if found, shall be immediately taken before the magistrate, who shall make such order as in the circumstance of the case seems proper. As far as the role of the subordinate courts in the exercise of the inherent power, the legislature has made detailed provision in the statutes, but the legislature may not anticipate each and every problem that may occur after years and years of passing the enactment. Therefore, inherent powers of that court can be exercised by such courts as laid down and under section 151 of the Code of Civil Procedure 1908. It is provided that nothing in this court shall be deemed to limit or otherwise affect the inherent power of the court to make such order as may be necessary for the ends of justice or to prevent the abuse of the process of the court. The inherent powers of the civil court are to be exercised by it in very exceptional circumstances. This power is exercised very sparingly when the court considers it absolutely necessary for the ends of justice or to prevent the abuse of the process of the court. The legislature has made detailed provisions in the code for various matters. If there are express provisions in the code covering a particular topic, then no power shall be exercised under the inherent power. So friends, let us conclude. When one talks about the protection of human rights, one will be interested mostly to the powers of the high courts and the Supreme Court under the Constitution, but it is equally important to appreciate the role of the subordinate courts as well as in this area the Code of Civil Procedure 1908, the Specific Relief Act 1963 and the Code of Criminal Procedure 1973. These are some of the enactments which lay down the procedure and power of the subordinate civil and criminal courts in granting relief. The Code of Civil Procedure providing the procedure for maintaining a right in the filing suits between the parties, popularly known as civil suits. The court also lays down the suit of public nature called the relator action is a very useful remedy to vindicate a right of public nature. The criminal courts having power to issue search warrants and operating akin to the writ of habeas corpus is another dimension of the role of the subordinate judiciary in the protection of the human rights. The power of the district magistrate, subdivisional magistrate and judicial magistrate of the first class to exercise the power of restoration of the abducted females and the power to issue search warrants to set free a person who is wrongfully confined are the areas where the subordinate judiciary can play a considerable role. The inherent powers of the civil court is another area where the civil courts may act in any matter where the lawmakers have left out and may pass order for the ends of justice or to prevent the abuse of the process of the court. So friends, this much for today. Have a good day. Thank you very much.